Hi there. Welcome to Help Solve the Case. My name is Christine Burke, retired police detective and sergeant, current law enforcement expert witness, and forensic genetic genealogist. And thank you for being here. Today, we are talking about a very interesting case, the case of Dr. Samuel Lee from Florida, who is being charged with manslaughter. And it's related to some sort of a ceremony that may fall outside of the bounds of medical practice. There are some allegations that I saw. I have not gotten into the case, but it looks to be very interesting. So I thought you'd want to see it. I thought maybe you'd want to follow it. So let's take a look at it. Okay. So this is in Florida, and this is out of Miami-Dade County. Like I said, very interesting. And this is the state of Florida versus Samuel by, I can't read it under that, Bayan Sung Lee. Let me fix where I am for you guys. Move over here. See if I can zoom you in. Okay. Hopefully I'm not too in the way. Okay. It's covered with that, so I can't say. So it's manslaughter, 782.07, subsection 1, a felony 2 of the second degree. All right. And so Catherine Fernandez Rundle, the state attorney of the 11th Judicial Circuit, goes through and says here, count 1, on or between February 1st, 2025 and February 10th, 2025 in the county and state aforesaid, did feloniously by act, procurement, or culpable negligence without lawful justification or excuse inflict upon Tina Sodai wounds or injuries which resulted in the death of said Tina Sodai, hopefully I'm saying her name right, a human being, by organizing and orchestrating the, quote, heart protocol ceremony, end quote, which included the defendant providing Tina Sodai with a mixture of illicit controlled substances such as ketamine, let me see if I can say this, methylene dioxymethamphetamine, and N-dimethyltryptamine without any medical safeguards in place, recommending Tina Sodai participate in a liquid parasite cleanse immediately preceding the ceremony and providing a facility as part of the ceremony that had access to a sauna in violation of 782.07(1) and 775.087 Florida statute, contrary to the form of the statute in such cases made and provided and against the peace and dignity of the state of Florida. All right, that was done here. This was May 7th. This is what we call an information, okay? So let's get into the details here. That sounds kind of crazy, right? And we've seen a lot of, like with Matthew Perry, we've seen a lot of these Michael Jackson, these drug-inducing doctor kind of things. Should they be held liable? Some states are moving to prosecute people that supply dangerous drugs and stuff. So I think this is very interesting, whatever this heart protocol ceremony was. So going back here, this just recently got filed. And this is for a pretrial detention pursuant to Florida statutes 907.041 5D. And I don't know if he was out or what, but okay, State Attorney Rundle wants the court to enter an order detaining the defendant in custody pending a final hearing on pretrial detention. And here's the grounds, and we're going to get into the details. The offense for which the defendant is presently charged, manslaughter, is a dangerous crime. The state believes that it can show substantial probability that the defendant committed the charged offense, that the defendant meets one of the conditions for pretrial detention contained in 907.041, subsection 5, and show beyond a reasonable doubt the need for pretrial detention pursuant to the criteria in 907.041. In lieu of detention, the state requests that the defendant be ordered to turn in all passports to the clerk of the courts and be ordered not to provide any medical, psychiatric, or psychological care in connection with, quote, the heart protocol, end quote, during the pendency of this case. The arrest warrant is hereby incorporated by this reference for the essential facts, and that's what we're going to look at. And the undersigned assistant state attorney hereby certifies that she has received testimony supporting the grounds and essential facts alleged in this motion. Wherefore the state, blah, 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 moves the court to find there is probable cause to believe that the defendant should be detained in custody pending a final hearing on pretrial detention, which shall be set 5 days from the filing of this motion. And they filed it the 13th, okay? So there should be an answer, if not today, maybe Monday or Tuesday. I didn't see anything else in the docket. Okay, but here I got to put my glasses on because maybe I need to move myself. Let me move myself over here. That might get it out of the way for you guys. Okay, so this is an arrest warrant. Okay, it says Samuel Lee. And we got some particulars up here. I'm going to blur that out, hopefully, if I can do that. Let's see. So before me personally came Detective V. Gonzalez, a affiant, who being duly sworn, so they said the defendant, Samuel Byung Sung Lee, I don't know if I'm saying that right, did commit the acts stated in the attached statement of facts. Okay, that's our probable cause. Based upon the sworn statement of facts, I find probable cause that Samuel Lee did commit the crimes of manslaughter. And it says $50,000 plus no prescribing of medical care. Okay, I guess that's the bond. Police case number 2025-15738, Miami Beach Police. Full extradition. That was signed on April 10th. Okay. So this is Judge, it looks like Ellen Venzer, a judge of the Circuit Court of the 11th Judicial Circuit in and for Miami-Dade County, personally appeared Detective Brian Gonzalez, badge 02-1137, a homicide detective with the Miami Beach Police Department, who being duly sworn, deposed, that's typo, should be deposes, and said, and typos, and should be deposes and says that there's probable cause to arrest the following person. Okay. Statement of facts. Your affiant has been a police officer for 20 years, of which 1 year has been spent as a criminal investigator in the Major Crimes Unit. He has been employed with the City of Miami Beach Police Department for the past 10 years and is currently assigned to the Homicide Major Crimes Unit. Your affiant has also worked for the Miami Beach Police Department K-9 Unit and worked in that capacity for approximately 6 years. Prior to being employed by the City of Miami Beach, he was employed by the Hialeah Police Department for approximately 9 years, where he served as a patrol officer. Your affiant is investigating a death that occurred at 1320 Flamingo Way, Miami Beach, on February 10th, 2025, reported under Miami Beach Police case number 2025-15738. During the investigation, your affiant learned the following. On February 10, 2025, at approximately 0844 hours, Miami Beach Police and Fire Rescue were dispatched to 1320 Flamingo Way in reference to an unresponsive female, who later was identified as Tina Sodai, hereinafter referred to as the victim. Officers were directed to the roof patio area, where a sauna is adjacent to the top of the stairs. Inside the sauna is where the unresponsive body of the victim was located. Officer Perez took over life-saving measures from a male who was performing CPR, later identified as Samuel Lee, hereinafter referred to as the subject. Miami Beach Fire Rescue, E1 and R2 arrived and pronounced the victim deceased at 0852 hours. A major crimes homicide detective was requested by Officer Perez. Your affiant responded to the scene. Okay, so let me stop there. So that's interesting because something for them to call out homicide, unattended death, or something happening, they immediately called out, is what we don't know exactly, but they immediately called out homicide, right? I was raised as a cop in Florida, South Florida. Everything's a homicide until it's not, okay? And it not being attended by a medical doctor now, we know we believe, allegedly, that Dr. Lee is a doctor. That's the way he's listed, but they got a homicide right away. Okay, they called out a detective right away. Typically for unattended death, you don't know what happened. So that's good. Okay, so let's see what happened. A major crimes homicide detective was requested by Officer Perez. Your affiant responded to the scene and assumed responsibility over the investigation. Yes, they do. Upon examination of the scene and of the victim, your affiant observed the victim inside the sauna dressed in a bathing suit and laying in a supine position on the sauna bench. The victim was cold to the touch, rigor mortis was present, and lividity was consistent with the supine position. So what they're saying, that she had been in there for some time, lividity was consistent with the supine position. So if you don't know what lividity is blood pooling. Okay, and that's how we as officers can tell when, or it's doctors, whatever, medical response personnel, you can tell if somebody's been moved because the lividity will not match the way the body is. Okay. No obvious signs of trauma or foul play were detected on the scene, but see, they still immediately called the detectives. The Miami-Dade Medical Examiner's Office responded and transported the victim to their office. It should be noted that the preliminary investigation was not conducted as a criminal investigation, so that's interesting, although they called homicide. Okay, they hedged their bets, they called the detectives, that's how I was trained, and then you wait on the medical examiner's ruling, okay? But you get the detectives to the scene right away. You don't destroy the scene and let all kinds of crazy stuff happen. You always play it safe. That's how I was trained. Okay. So they said the parties involved were not sought as suspects. Their interviews were given freely and voluntarily. Okay, that's an interesting point. So that means that they were not in custody, they were not subject to Miranda, and they were just witnesses according to the officer. So custodial Miranda would not apply, right? So it's very important, it's very interesting and important that he wrote this and he said, he's elaborating and really making it clear here that even though they were called, they didn't investigate it as a criminal. It was not a crime at that time. So therefore, the witnesses were not suspects. Nobody was a suspect. And I believe before he said the person was the subject. Okay, not a suspect, a subject. And so they're protecting constitutionally the right for those interviews that were freely and voluntarily given. Here we go again. A recorded interview of the subject was conducted on site by a body-worn camera. Your affiant learned the following. Okay, so sounds like this detective might have a body-worn camera. We don't see that all across the board, do we? Now, I don't know if he just had a patrol officer with him or what, but that's good, okay? According to this subject, and note it's in quotes here, he is a licensed medical doctor and an elder of the Eternal Life Tribe. I don't know what that is. The purpose of his stay at the incident location, Sabia Wellness Health, was to conduct the, quote, heart protocol, end quote. The, quote, heart protocol is a treatment holistic in nature that consists of the subject administering, facilitating a GABA agonist, pure MDMA, and ketamine. Now, GABA is so an agonist is either for or against, either suppresses or activates. And GABA is typically, from my understanding, and we'll have to look at it, I'm just trying to pull it out of my head, a calming type thing. So I'm not sure. We can look that up. The subject advised these substances were provided by him to the victim and one other participant throughout Saturday, February 8, 2025, and not given all at once. The subject also advised that this treatment was a sacred sacrament of the church and not performed under his medical license. So, they were giving MDMA. Okay, so there must be something else. I'm wondering if this GABA agonist is one of the items, pure MDMA, and ketamine is the other. Not sure. So they're saying that this was a sacred sacrament of the church versus state. Think about that. And not performed under his medical license as a doctor. The GABA agonist, okay, so there is a third chemical or whatever, and MDMA were taken orally by the victim and the other participant. The subject, again, which is Dr. Lee, performed an intramuscular injection of ketamine to the victim and the other participant. The subject also advised that this was the second time the victim participated in the HEART protocol. A recorded interview of Ariana Vanin, herein referred to as AV, was conducted on site by a body-worn camera. Your affiant learned the following. AV is the homeowner of the incident location, 1320 Flamingo Way, that might be the house, where she both resides and operates a business known as Sabia Wellness House. AV stated that the subject was staying and using the location to conduct the HEART protocol with two participants, one of whom was the victim. AV further advised that she was present at the beginning of the ceremony and observed the victim take GABA, quote GABA. AV then left the house to provide the subject and participants privacy while the ceremony continued. AV also advised that she has personally participated in the HEART protocol on 2 occasions and has observed numerous other individuals undergo the same ceremony. AV further stated that the victim was familiar with the sauna on the property, having used it numerous times prior to her untimely death. It should be noted that the incident location is located within a residential, non-commercial zone. Now, that may apply to the statute, it may apply to the charges, maybe because he's a doctor, they're looking at commercial doctor zone, although Dr. Lee, appears from the report to be specific, saying that he was not operating under his medical license, okay? Just throwing that out there, the pieces that I see, okay? An area canvass for video surveillance in the area of the incident was conducted, okay? Ring video footage confirmed that no other individuals were observed visiting the location during the relevant time, okay? So they're trying to pin down who could have possibly been there during this occurrence. Okay, so they're saying this picture says that's the house. Okay, looks like a nice patio there. Okay, there's the roof terrace. I think that's probably the sauna. This picture with the reflective roof is the sauna. Maybe, I don't know, that looks like a sauna to me. Okay. On February 18, 2026, a second recorded interview of AV was conducted at the Miami Beach Police Criminal Investigations Division by a body-worn camera. Your affiant learned the following. I'm glad that these detectives are using body-worn cameras. AV confirmed that on February 8th and February 9th, 2025, so we're talking almost a year and a half later, right? The only individuals present at Sabia Wellness House were herself, the subject, who's Dr. Lee, and the victim and CO, that's the other person. AV stated that no other individuals visited the property during those dates. She further advised and reconfirmed that she was not present during the ceremony. AV also described the types of substances typically administered during the HEART protocol, to include GABA, MDMA, and ketamine, and stated that she does not supply or provide these substances. Remember, they're going after people that supply deadly substances or substances that led to people's death, right? The subject requests, and she allows him to use her property to perform the ceremony. Consent was obtained to search AV's cellular phone, and a forensic digital extraction was conducted. The analysis revealed communications documenting the planning, coordination, and execution of multiple HEART protocol ceremonies at Sabia Wellness House. Now, the fact that they said that the house was not in the commercial zone, and it's being called Sabia Wellness House. Depending on what's going on there could be some licensing, whatever. We're not sure. AV also mentioned that, to her knowledge, the victim did not take any other substances because the victim was fasting. Okay, I can see where this is going. She further confirmed that the subject is the sole provider of the mentioned substances and was the only facilitator of the HEART protocol. And this is good. This is good. They got the agent signing it and the judge initialing it. So you can tell there's no changes here. I love Florida. Okay. On February 17th, not the humidity and all that, and I don't live there for certain reasons, but I do love, I've mentioned this in other cases, how they do their stuff. Okay. On February 17, 2025, a recorded interview of Chad Olin, okay, hereinafter referred to as CO, was conducted at the Miami Beach Police Criminal Investigations Division via Axon cameras. Your affiant learned the following. CO was the second and only other participant, excuse me, of the HEART protocol on February 8, 2025. CO stated that he was there for a ketamine treatment, referring to the HEART protocol provided by Dr. Samuel Lee, the subject. He advised prior to participation in the HEART protocol, he signed a liability waiver form that was completed online. He described his experience of the HEART protocol with the following events chronologically. Taking 1 to 2 pills, he didn't know what they were, microdose of ketamine injection into his arm by Dr. Lee, breath work, and to continue their ceremony, both participants were instructed to go into their individual bedrooms where a second microdose of ketamine was given by Dr. Lee. The subject monitored CO for approximately 30 minutes. A third dose of ketamine was given to CO by the subject at CO's request. On March 22, 2025, a forensic digital extraction was conducted of the victim's cellular phone. The data revealed communications, including WhatsApp messages and emails between the victim, the subject, and staff members associated with the subject's company, Transcendence Mental Health. Now, we heard earlier, I thought that they were saying this was a religious ceremony. So I don't know if Transcendence Mental Health is the church, or I don't know, maybe they'll tell us. These communications show that she received a confirmation email for participating in the ceremony and a receipt for paying a $2,000 fee. It also showed that she signed a waiver stating her participation was voluntary and further acknowledged the potential side effects and risks of, quote, plant-based and Western psychedelic formulations, end quote. I wonder what those are. And her agreement to waive liability of the ceremony facilitators. Further communications documented the planning, pre-ceremony instructions, and scheduling for participation in the HEART protocol. In an email congratulating her for choosing to experience the HEART protocol, the victim was provided instructions for what to do prior to the ceremony, including completing a gastrointestinal parasite cleanse in the days immediately before. I'm start thinking when they talk plant-based, what is it, ayahuasca or whatever? I'm not sure. Voice messages left by the subject to the victim confirm this time frame to be roughly 2 days prior to the ceremony, and text messages between the victim and the subject reiterate the importance of a clean gut, potentially deeper ceremony. Yeah, because probably when there's nothing to block the absorption of whatever you ingest, right? Ceremonial instructions also provided to the victim included answers to commonly asked questions, including the safety of the ceremony and that no one had gone dark in the 2 years the ceremony had been conducted. What does that mean, gone dark? The following email exchange between the victim and the subject prior to the ceremony was also located. On February 6, 2025, the victim confirmed she had received her detox kit in the mail and would undergo the cleanse that day per the recommendation from the subject. She also confirmed that she drank the number of drinks over the course of the day along with a smoothie, coconut water, and water, but abstained from solid foods. On February 7, 2025, the victim received an email with a video attachment outlining the details of the ceremony. In the video, the subject claims the ketamine treatments have a novel, that's an interesting word, novel, quote, ceremonial aspect, end quote, and a, quote, clarigenic, end quote, rather than hallucinogenic impact due to the clarity that they bring. The subject mentions the use of an over-the-counter GABA supplement to, quote, relax the brain, end quote, 3 onboarding dosage of, quote, heart medicine, end quote, to increase serotonin and dopamine production, and, quote, open the heart, end quote, and an intramuscular injection of ketamine once the, quote, heart medicine is peaking, end quote. The subject explains the benefits of this 4 to 6 hour treatment include relief from depression, anxiety, suicidal ideation, addiction, and stress-related past traumas. On July 2nd, 2025, the Miami-Dade Medical Examiner's Office ruled the victim's cause of death to be hyponatremic dehydration due to confinement in a sauna and use of methylene dioxy, methamphetamine, and ketamine. Now, if she passed in February and this took until July, sometimes we always hear about waiting for tox, right? Toxicology. So, hyponatremic is either, liquids or nutritional dehydration from the sauna, okay? And then the drugs. So let's see. Miami-Dade Medical, and I'm not the doctor, so I'm sounding it out. Okay, we can look it up. Miami-Dade Medical Examiner's Office toxicology report revealed that the victim had methylene dioxymethamphetamine, okay, MDMA, ketamine, both metabolites, and N-dimethyltryptamine in her system. On March 20th, 2026, your affiant met with representatives of Miami-Dade Medical Examiner's Office who further advised that the victim's death was the result of a multifactorial combination of contributing predisposing factors. So it wasn't just one thing. A liquid parasite cleanse recommended by the subject, Zen cleanse, the administration and provision of the controlled substances, MDMA and ketamine, and the victim's exposure to an infrared sauna amplified the effect of the substances. The medical examiner explained that the combined effect of these factors created enough dehydration, okay, and stress to the body, and that each alone significantly contributed to the victim's death. So, if on alone, well, it says each alone significantly contributed. Would the sauna on its own have done it? Would the MDMA on its own done it? Would the ketamine done it? Would the parasite cleanse on its own? But it sounds like it was just too much for the body to handle. Maybe with the dehydration, the water, like the body couldn't process and eliminate all these chemicals. We don't know. All right, they're gonna tell us more. Hang on a second. They really did a good job. They worked hard on this. On March 24th, 2026, your affiant spoke with Dr. Alberto Augustin, a nationally recognized expert in clinical toxicology and psychopharmacology. From a pharmacologic and toxicologic perspective, Dr. Augustin explained that the substances referred to in the heart protocol, how many times do I have to say this? We're just going to say MDMA, ketamine are each associated with significant physiologic and neuropsychiatric risk. So each by themselves, particularly when used outside of regulated clinical or research settings, and that combined use may further increase the risk of adverse outcomes due to overlapping and potentially synergistic effects. So when they're together, they amplify. Dr. Augustin noted that MDMA are classified as Schedule I controlled substances under federal law and are not approved for general medical use outside of authorized research settings. Ketamine is a Schedule III controlled substance and may be used legally for valid medical purposes under the supervision of a licensed healthcare professional. Now, let's connect the dots. These are not approved for general medical use outside of authorized research settings. This is not a research setting. It's a house, right? It's not in a commercial property. Remember how they were laying all this out? It's not a commercial property. It's supposed to be used for valid medical purposes under the supervision of a licensed healthcare professional. But remember, Dr. Lee said he was not operating under his license. And remember, if we go back to that theme, the use of the word novel, okay, not sure. All these different parts, the totality of the circumstances are coming into play here. Okay. Okay. However, it needs to be, they may be used legally for valid medical purposes under the supervision of a licensed healthcare professional. However, it's not prescribed use or use outside of appropriate clinical oversight carries no risk and is illegal. Dr. Ogston further advised that the described setting and protocol used by the subject does not reflect a recognized or regulated clinical environment and would not be consistent with standard medical or research safeguards typically required for the administration of such substances. He also noted that these agents are commonly associated with dehydration, cardiovascular stress, and alterations in thermoregulations, body temp, okay? In this context, Dr. Ogston advised that engaging in a gastrointestinal or parasite cleanse prior to the ingestion of these substances could further exacerbate dehydration and electrolyte imbalance, thereby increasing physiologic risk. Additionally, exposure to high heat environments such as a sauna following the ingestion of these substances may further compound risks related to hyperthermia, not hyperthermia, cardiovascular strain, and impaired physiologic regulation. It is Dr. Ogston's opinion, to a reasonable degree of scientific certainty. Okay, I'm going to interrupt myself here because in the Tyler Robinson case, we had with, I believe, both the ATF witness and the FBI witness that the defense who called the witnesses, the experts, the crime scene and experts with the DOJ guidelines that they were not allowed to use this wording. Do you remember that? They could not use that to testify, right? Or maybe could not use it in reports, okay? But right here, here's an expert using these words. It is Dr. Ogston's opinion, to a reasonable degree of scientific certainty, that the actions taken by the subject reflects an extreme and unjustifiable deviation from accepted safety and clinical practices involving a convergence, gosh, all these words, of multiple foreseeable and compounding risk factors without appropriate safeguards, including the lack of medical oversight, use of controlled substances outside of regulated settings, potential dehydration, and access to extreme heat exposure without appropriate safeguards or medical supervision. Based on the totality of the circumstances, the scene investigation, subject and witness statements, expert medical and toxicological testimony, the medical examiner toxicology report, and digital forensic evidence, there is probable cause to believe that the subject unlawfully committed acts which caused the death of the victim and or which demonstrated that the suspect was culpably negligent. So they request that the arrest warrant be issued for manslaughter. There's his email. Okay. All right. So, interesting, isn't it? I think that this is going to be a good case to watch because I want to see how they defend it. That affidavit is very important because of the constitutional provisions, what I think, right? Remember, we look at it from all perspectives, defense perspective, prosecutor perspective, jury perspective. And I thank you for being here. This is what I love doing. I'm trying to, when I worked as a police officer, you can't just, well, you can, a cop can, but I always like looking in the future and saying, what are we potentially facing? Let's make sure all our ducks are in a row. So they did that. They called the detective to the scene. They weren't sure if they had what they had with the death, right? It could have been somebody just dying in the sauna, heart attack or whatever. Maybe they heard something about the ceremony and they immediately called the detective. But the fact that, and the detective, articulated it specifically in specific areas about subject, and it wasn't a criminal investigation. And they're probably going to say it was just process, because I will tell you, that's how I learned. Everybody who knows me says a death is always a homicide until otherwise. Okay. And who makes the determination? Not the officer. The medical examiner always makes the determination. So I got called out on all deaths if there was a doctor not willing to sign the death certificate. That's how we do it in Florida. That's how we roll. Okay. So they're probably going to say, we were just there as part of our policy and procedure. That's how we do it. Okay. Because the death is a homicide until, just like I articulate. Okay. So this is going to be good. Now, the defense is probably going to come back and say, no, you knew. You had an idea. You had a suspicion, right? You had a suspicion and you held them there to talk to them. So they were in custody, right? Right? Because then the custodial and Miranda applies. Now, we did not hear, right? We've got the body-worn camera, supposedly, and we don't know if there was a further interview of Dr. Lee. We don't know. Okay, so that's why I think this is going to be procedurally. I mean, the case is right, rare of what happened, although we're seeing more charges being filed. We've got the religious versus state issue here. We've got the medical license, but not the medical license. We got this operating out of the house, but not being in a doctor's office. Very, very interesting. So I think this will be a really good one to watch. And I know it was a little weird with the public documents, but I think we'll have the public documents available. So what do you think? What do you think? I think this will be a good case to watch. So once again, thank you for being here, and I will see you on the next one.